Okay, I have spent considerable time pondering all of the issues that are facing agents based on this change in the recent change to go to completely a due diligence period in the South Carolina state contract. I've talked to a lot of agents, I've taught classes, I've gotten phone calls, I've talked to broker in charges. And my concern is that there are too many unanswered questions. And that those questions must be answered and they must be decided upon between the parties and they must be included in the contract. Otherwise, you could have issues, and I believe that is legally required for it to be enforceable. There is nothing else that I know of that we say we'll just leave it to the parties to figure out later. Our license law, our ethics rules, and just purely contract law says that all terms and conditions must be in the contract. So again, I do feel that the main problem is the termination fee. So I am an escrow agent for some of my clients ask me to hold earnest money. So I realize I'm putting this on escrow agents. But I think the best possible solution is for the termination fee to be delivered to the escrow agent and upfront. The reason I say upfront is to, one, make sure that whatever termination fee is to be paid, the buyer has it, that there would be no collectability issue should something arise and the contract be terminated and there be a buyer out of state or somewhere that says, I'm just not going to pay it. But the main reason for this is if it's paid up front, then it eliminates the how do you deliver it and what if you miss the deadline argument or dilemma, not argument. So I would suggest that the buyer pay the termination fee specified in paragraph 8 to the escrow agent is specified in paragraph 5 by 6 p.m. on a certain date. Now, that may mean you don't want to pay it with the contract and the earnest money, but certainly not long after that. It could accompany it. It would need to be 2 checks. Remember, there's earnest money does not change by any of these, this adoption of a due diligence. The language did not change any other paragraph of the contract, so earnest money is still the same. Then I would suggest the same provision be there, that if the buyer fails to pay the termination fee by the time specified in this addendum, that the seller can terminate the contract by delivering a notice of termination. That is basically the same language we find with earnest money. Now, once the escrow agent has it, and the reason I don't think this puts an undue burden on escrow agents, as attorneys, we must keep any fees we have, any money we have for someone else must be safeguarded. We have very strict safeguarding rules in our ethics rules, and it must be safeguarded by depositing it into a trust account. That would be true even if necessarily someone weren't my client and just said, hey, Carol, I would like for you to hold this money for me. Then I would need to deposit that money into my trust account. So that being true, I now then am depositing 2 checks instead of 1. I'm depositing an earnest money check and a termination fee check. And then I would hold it. If the buyer terminates by giving a notice of termination during the due diligence period, then the addendum would instruct me as an escrow agent to disperse the termination fee to the seller upon the receipt of the notice of termination signed by the buyer. I would like a copy of that notice of termination just to basically confirm with everyone that the buyer believes they have terminated during the due diligence period. If the buyer does not deliver the notice of termination during the due diligence period to terminate the contract, then that would be the buyer's money. It could either be applied at the closing or it could be refunded to the buyer. In this particular market with our low interest rates, it's not like keeping that money in my escrow account for another couple of weeks until the closing is going to cost the buyer a lot of interest. But I guess in all fairness, he should have the opportunity to ask for that back, or it would be a credit at closing. Now, the other issue that I think arises is when is delivery complete? We certainly don't want to just create another set of issues of delivery of this fee by saying if it's to the escrow agent late, we're in trouble. So I would define in the addendum how delivery is complete. Okay, I would think certainly that if the fee is delivered by hand, then it's the delivery is complete when it's delivered. Okay, if the fee is sent by wire, then the delivery is complete at the date on the date and time of the wire confirmation. This would eliminate any risks that possibly the bank, a particular bank, I know getting funding sometimes there are banks that only do wires at certain times during the day. So that being the case, if the bank then there was a delay in the wire transfer, that would not penalize the buyer. Then we may have about an overnight service I talked about UPS in another video. Well, again, it's not the buyer's fault if UPS messes up. And so certainly that is a third party doing something. So I would have in the addendum that delivery is complete upon deposit with the overnight courier with the fees paid and the proper address, etc. We have in the IRS that if you postmark something, that IRS actually goes by postmark, so that if you postmark and put it in the regular mail, it was sent in regular first class mail or certified or registered mail, that it would be in the postmark. We then have the possible transfer of money through mobile or the peer-to-peer apps, payment apps such as Cash App, Venmo, I'll get that right eventually, PayPal, Zelle, etc. So that I think should be considered delivered at the time shown on the proof of payment. And then if for some reason the buyer just wants to deposit it into the escrow agent's account, then of course it would be the time shown on the deposit receipt. Now, I understand that there are some escrow agents on the margin who are going to say, why do I want to hold this money? As I'm teaching, I've said again and again, why do I want to hold this money? Because by definition, I'm not getting the closing. Well, my answer to that is I don't think it will kill me to write one more check at termination. I still, if I'm holding the earnest money, have to handle the earnest money in the way that earnest money is handled under the contract. But I think this would eliminate any of the panic over termination and getting that termination fee to the proper party. That's just my thought of how it should be handled. I'm sure other people will have other thoughts and will find something wrong with what I've said, but that's what I think.